today's faculty, Shri Jignesh Parikh sir. I request Jiten sir and Shikha ma'am to welcome the faculty on the dais. Jignesh Parikh sir is a highly experienced professional, having a practice as a chartered accountant for 15 years, and currently he is practicing as an advocate since last 2 years. He has delivered so many lectures on the income tax topics at ICAI branch, study circle, and the different associations. Also, he is a regular contributor to the insightful articles on the subject lines. His deep understanding of the judicial discipline and propriety under income tax, especially the importance of the following High Court decisions and maintaining consistency in administration, makes him a respectable voice in this field. I request Jiten sir and Shikha ma'am to welcome the faculty with a bouquet and memento.
Honorable the Chairman, sir, Honorable Managing Committee members, other dignitaries on dais and off the dais. It is indeed a matter of pride and privilege to be here and to deliver a talk on this interesting topic, that is judicial discipline. When we talk about discipline, we actually talk about the rules that one has to follow, the rules that one has to obey, and the things should work according to the settled rules only. If those rules are not followed, if that discipline is not followed, there is going to be a chaos, things are going to be haywire. If we discuss this topic from the angle of income tax, so judicial discipline with respect to income tax proceedings, assume a scenario that there is no judicial discipline, meaning thereby everybody would try their hands before judiciary for a similar for similar kind of issues. Matter may be decided in my favor, some other person goes, matter may not be decided in his favor, the facts are identical. That should not be a case, and that is not a healthy sign for any economy. Hence, judicial discipline is very much needed. Second part is, now the things have gone faceless. Since the things have gone faceless, we are experiencing the faceless scenarios so far as assessments are concerned, appeals are concerned, and tribunal may go faceless soon. So at that juncture as well, the judicial discipline would become more important, more precisely that in our submissions we need to quote certain judgments that, let's take an example. This is a Gujarat High Court decision. Gujarat is the jurisdictional High Court decision, and why the jurisdictional High Court decision is binding on the over the other judgments if at all available. So those all need to be a part of the our submission as well, so that it becomes easier even for us to ensure that we get our desired results. Coming to, if we start the discussion from the first, let's say the Supreme Court decisions. If we talk about the Supreme Court, we know that Article 141 of the Constitution of India, Article 141 provides that law declared by Supreme Court to be binding on all courts. The law declared by the Supreme Court shall be binding on all courts within the territory of India. So the law which is given by Supreme Court will bind to everyone. One cannot come up with an argument that had this argument be delivered this wise, things could have been different. This matter has not been argued well. This matter, a particular line of argument has not been forwarded to the court. This all arguments will not work. If it is a law decided by the Supreme Court, it will hold good and it will hold the field and it would be applicable, it would be binding to everyone. We have a direct judgment on this, and that judgment is on the case of Sinoy and Company versus CIT 1985, 155 ITR 178. We also have similar judgment in the case of Sonavanti versus State of Punjab 1963 33 compute case, 745 Supreme Court, and we have Ballabh Das Mathur Das Lakhani versus Municipal Committee, AIR 1970 Supreme Court 1002. The ratio which is coming out of them is the law laid down by the Supreme Court is binding on all, notwithstanding the fact that it is against the state or a private party. It is binding even on those who are not the parties. It is binding even on those who are not parties before the court. Also, as per Article 141 of the Constitution of India, the law declared by the Supreme Court shall be binding on all courts within the territory of India. The binding effect of Supreme Court decision on a question of law does not depend upon whether a particular argument was considered therein or not, provided that the point with reference to which an argument was subsequently advanced was actually decided. Similarly, if we say that there are two decisions of the Supreme Court, the larger bench decision would prevail over a smaller bench decision. Even if the later decision is of a smaller bench, still the larger bench decision would prevail. And to that aspect, with respect to that, we have direct judgment in the case of Berger Paints, India Limited, 2004, 266 ITR 462. Now, if we, this leads towards a question that, let's say a decision has been delivered by a court. Will that decision be a prospective or a retrospective? Will it have application prospectively, or that is to say from the date of the order, or it would have a retrospective application? So we have on that a direct judgment once again, wherein it has been said that in the case of M.A. Murthy versus State of Karnataka, 2003, 185 CTR 194 Supreme Court, then they held that normally the decision of this court enunciating a principle of law is applicable to all cases irrespective at the stage of the pendency, because it is assumed that what is enunciated by the Supreme Court in fact the law from the inception. So it is going to be retrospective unless otherwise categorically stated in the judgment that it will be prospective. Otherwise, the judgments delivered by the court will be considered as retrospective. We have similar judgment in the case of ACIT versus Saurashtra Kutch Stock Exchange Limited, 2008 305 ITR 277. The court held that a judicial decision acts retrospectively. The judges do not make a law, they only discover or find the correct law. The law has always been the same, and if a subsequent decision alters the earlier one, the later decision does not make a new law, it only discovers the correct principle of law which has to be applied retrospectively. The Supreme Court held that even an earlier decision of the court operated for quite some time, the decision rendered later on would have retrospective effect, clarifying the legal position which was earlier not correctly understood. So this makes the things pretty clear that a decision delivered by a court would have a retrospective effect, and it cannot be assumed to have a prospective effect. Now that leads towards another question, that whether ratio decidendi of the Supreme Court would be binding. Yes, it would be binding to everybody. Even obiter dictum of the Supreme Court decision, that will be binding everyone. The question that really comes is, what is ratio decidendi? How to find out from the judgment what is ratio decidendi? We have a recent judgment of the Supreme Court. It's a 9-bench judgment of the Supreme Court in the case of Property Owners Association and others versus State of Maharashtra, 2024 INS seat 835. In that case, they would talk about a particular test. They say that आपका जो भी जजमेंट है, जिस जजमेंट में जो ऑब्जर्वेशन है, अगर उसको उल्टा कर दिया जाए तो क्या उल्टा करने के बाद भी आपका अल्टीमेट आउटकम सेम रहेगा? अगर उसे उल्टा करने के बाद भी, उस ऑब्जर्वेशन को अगर मैं उल्टा भी कर दूं, अगर उसके बाद भी आउटकम सेम रहेगा, इन दैट केस इट वुड बिकम अगर उल्टा करने के बाद आउटकम सेम रहेगा तो वो रेशियो नहीं है. अगर उल्टा करने के बाद अगर आउटकम बदल जाता है, then it is going to be a ratio. So in that judgment in para 114, the Supreme Court says that further a simple test has been invoked by this court to determine whether a particular proposition of the law is to be treated as a ratio decidendi of a case is the inversion test formulated by a very senior professor, Professor Angu. The test mandates that to determine whether a particular proposition of a law is a part of the ratio decidendi of the case, the proposition is to be inversed. This means that either that proposition is hypothetically removed from the judgment, or it is assumed that the proposition was decided in reverse. After such removal or reversal, if the decision of the court on that issue before it would remain the same, then the observation cannot be regarded as the ratio decidendi of the case. So that is whether a particular observation is a ratio decidendi or not, that we can identify using this particular paragraph. Another issue which comes up is, let's say there is an SLP which has been filed against an High Court decision, then SLP is filed before the Supreme Court. Now the question is that whether this SLP, let's say, is dismissed, option 1. Option 2, it is admitted. Whether dismissal of the SLP would tantamount to merger of the High Court order to order with the Supreme Court's order? The answer is no. Even if SLP is dismissed, it does not mean that the High Court order has merged with the order of Supreme Court. It might be dismissed by simply quoting the word dismissed, or they might have written 1 or 2 lines that we have considered the judgment of the High Court, and the special leave petition filed by the petitioner is dismissed, the leave is not granted to file the appeal. So if that be the case, in that case, the High Court decision does not become a Supreme Court decision, or the order of the High Court does not merge with the Supreme Court order. It would be only a scenario where, let's say, a Supreme Court, let's take an example. I have filed an SLP. SLP is admitted. Once SLP is admitted, it became a civil appeal. Once it becomes a civil appeal, and then thereafter if the Supreme Court comes up with a decision, that would be binding. Even it may so happen that in that decision they might have written even a 1 word, let's say dismissed. They only written 1 word, dismissed. Even that civil appeal would become a binding force. This was happened one of very old matters, probably somewhere in 1980, probably in Nirma Limited case, this was the issue. What has happened in that particular case is the Honorable Gujarat High Court has decided, has taken a view against assessee. Originally, Gujarat High Court has taken a view on a particular matter against assessee. Madras High Court was in the favor. Against the order of the Madras High Court, department went to the Supreme Court. SLP was admitted, and thereafter they passed an order saying dismissed. Now, when Nirma Limited's matter came up before the High Court, the issue before the High Court was, should the High Court follow its own decision, that is the Gujarat High Court decision which was against, or should now it be assumed that the Madras, or treated as Madras High Court order, has merged with the Supreme Court order? They held that now since SLP is admitted and thereafter it is dismissed, whether it was a reasoned order or not, now the Madras High Court order has merged with that order of the Supreme Court. So now the Gujarat High Court said that I will not follow our order, now that Supreme Court order would prevail. And to that effect, we have a direct judgment. One more judgment about the SLP which we spoke about is Kanhaiya Muhammad versus State of Kerala, 2006 SCC 359 is the relevant judgment for that. We have one more judgment, P. Singarwa versus District Collector, Supreme Court, right? The same issue that they have also discussed. Now we come to the High Court decision. Now when we talk about High Court decision and the judicial discipline with respect to that, there are various permutation combination. Number A, the jurisdictional High Court decision. Number B, there is only one decision, that is of a jurisdictional High Court. Number B, jurisdictional High Court is in my favor, and the High Court other than the jurisdictional High Court may not be in my favor. The third situation, there is no decision on a particular issue by a jurisdictional High Court, but we have a decision of a non-jurisdictional High Court. The fourth category is we don't have a jurisdictional High Court decision, the non-jurisdictional High Court has passed an order, but then there is no any other order available. The fourth situation is jurisdictional High Court has not passed an order, there are various orders of the non-jurisdictional High Court is available and they have conflicting views. The fifth possibility is, at the same point of time, we have a special bench order as well. So in all those different permutation combinations, what judgment would prevail and what should be the case? Now let's deal with the situation that we have a jurisdictional High Court decision. If we have a jurisdiction High Court decision, then the tribunal subordinate to that jurisdiction, or the courts which are subordinate to that particular High Court, will have to obey to the decision of that particular jurisdictional High Court, unless otherwise that decision has been stayed by the Supreme Court, it has been reversed by the Supreme Court. So that judgment will remain in force and they have to follow. We have experienced that particular situation in our PF ESIC related matter, that is GSRTC was against us. So even if the other high courts were in favor, our tribunals used to follow GSRTC, right? Because jurisdictional High Court will have a binding force. Similar would be a case, let's say we do not have any judgment in our favor. I mean, we do not have a jurisdictional High Court judgment. We have a judgment of any other High Court, but then this is the only judgment which holds the field. So let's take an example. We have a Madras High Court judgment somewhere in November 2024, and they have stated that the increased rate of tax of 60% will be applicable from 1/4/2017. So for financial year 16-17, increased rate of tax of 60% will not be applicable. To my mind, this is the only judgment we have of the High Court. We do not have any other judgment. We have some other tribunals, but then we don't have any other High Court judgment. Now, in that particular circumstances, we don't have Gujarat High Court at least. Now, if a matter goes to a tribunal, the tribunal has to follow the judgment of that particular non-jurisdictional High Court. It has no choice, that has to be followed. And for that, we have a direct judgment in the case of Godavari Saraf. Bombay High Court has taken a view that if this is the only judgment of a non-jurisdictional High Court, and if that holds a field, that has to be followed. That leads towards a different situation. As I mentioned, the third situation. We don't have a Gujarat High Court judgment. We have a judgment of Bombay High Court, we have a judgment of Delhi High Court, we have a judgment of, let's say, Punjab and Haryana High Court, but then we don't have a Gujarat High Court judgment. I'm talking about the Jao Fao matter. We are aware that Bombay High Court, hexaware in the favor, Delhi High Court is against, Telangana High Court is in favor, Guwahati High Court is in favor, Calcutta High Court is against, Madras High Court is against. So we don't have Gujarat High Court. Now, what would happen whether this particular judgment, what are they binding? What is to be done? So now we have one judgment of the Supreme Court, that is vegetable products. I'll give you the citation for that. Just give me a minute. Vegetable Products Limited, 1973, 88 ITR 192, they have held that in case of the conflicting decisions, the view in favor of the assessee has to be followed. Similar, we have one more judgment in the case of Chief Commissioner of CGST versus Safari Retreats Private Limited, 2024, 167 taxman.com, 73 Supreme Court has held that even if two interpretations of a statutory provisions are possible, the court ordinarily would interpret the provisions in favor of a taxpayer and against the revenue. So these two judgments are later on followed recently by Jodhpur Tribunal. In Jodhpur Tribunal, that is 2024 169 taxman.com 298, and Delhi Tribunal in case of 2024 169 taxman.com 379, ACIT versus Winit Investments Private Limited. And they have said that when there are two decisions of two conflicting high courts are available, the view in favor of the assessee has to be taken. However, it may so happen that we have one judgment where it has been mentioned that if there are two views available, the view which appeals to the court, appeals to the tribunal, they may take, and that judgment is in case of, if I am not mistaken, Thane, sorry. The Thane Electricity Supply Limited, 1994 206 ITR 727, Honorable the Bombay High Court observed that the decision of one High Court is so now the question that, here the question was, here we discussed, in the first part we discussed that whether the judgment of the High Court, that would be binding to tribunal or what would be a scenario. Now whether the judgment of one High Court, whether that would be binding to other High Court or not. So we discussed the first situation where we spoke about Zhao and Fao, where we saw that the decisions of, they're divided. Now what would be a situation if matter goes to tribunal? Tribunal can take a view, as such as we discussed that relying on the vegetable products, one can have an argument that the view in favor of the assessee has to be taken. However, there are certain judgments where a view has been taken that if a later judgment has explained the earlier judgment and after explaining that judgment they have been distinguished, then it would be open for a tribunal to take a decision which is a later decision, and that particular decision may be against. So now that leads towards a question that what would happen, let us say if a matter goes, Zhao Fao matter goes to a tribunal. Of course, so far as the state of Bombay is concerned, it has to be in favor. So far as the state of Punjab and Haryana is concerned, it has to be in favor. So far as the state of Telangana is concerned, it has to be in favor. So far as Delhi NCR is concerned, it is going to be against. Madras, it is against. What would happen, may ideally happen, I cannot say what would happen, what may happen if it goes before the Ahmedabad ICAI. Now if you refer to Madras High Court judgment, Madras High Court has considered all the other High Court decisions and then passed the order. So that leads towards a view that it may so happen that the Ahmedabad ICAI may take a view that the latest judgment is that of a Madras High Court, wherein all the earlier decisions have been explained and then taken a view, so we would go by the Madras High Court decision. Now, recently, I couldn't get the name of the judgment, but then recently against one Punjab and Haryana High Court, we know that the Punjab and Haryana High Court has passed an order in favor. That matter is anyway pending before the Supreme Court. In some other matter of Punjab and Haryana High Court, it was quashed, matter went to a Supreme Court in the bench of Paldiwala sir, and Justice Paldiwala stated that somewhere he made an observation while admitting SLP, that since in the other matters SLP has been issued, we are issuing the SLP in this particular matter, but it has to be 151A. So if we use that particular, of course, that observation has not a binding force. But then if that argument is forwarded by the other side, that the Madras High Court has explained all the judgments, then probably we have this one particular argument to make. We need to see how the things would move around. Anyway, this matter is pending and this probably is held for probably it is held for further argument somewhere in the month of September. But be that as it may, just to explain my point that when the different high courts have taken a different view and a matter is before a tribunal, in that particular case, ideal course of action for a tribunal, to my understanding, is relying on the vegetable products, the one view which is favoring the assessee, that has to be taken. However, it is open for the tribunal that they may say that the later decision will be followed, because in the later decision, the chronology or the earlier decisions have been explained. Now the question when it comes on, what would be a scenario whether the other decision of the other high court, will they have to follow the decision of some other high court? So whether Gujarat High Court is bound to follow the decision of the Bombay, whether Delhi High Court is bound to follow the decision of the Gujarat High Court. So to that effect, we have certain judgments. As a matter of fact, we have certain judgments available. Now, if we, in the case of CIT versus Chimanlal J. Dalal and Company, 1965, 57 ITR 285, the Bombay High Court held that, barring some exception, it has been a general policy laid down by this court, by the court in income tax matters, that whatever our own view may be, we should follow the view taken by another high court on the interpretation of a section. Similar judgment we have in the case of Arvind Brands and Paper Products Limited versus CIT, 1982, 137 ITR 635. In that case, the court observed that in income tax matters which are governed by an all India statute, when there is a decision of another high court on an interpretation of a statutory provision, it would be a wise judicial policy and practice not to take a different view, whatever one's own view may be, barring of course certain exceptions, like where the decision is sub silentio, per incurium, obiter dicta, or based on a concession, or take a view which is impossible to arrive at, or there is another view in that particular field, or there is a subsequent amendment of the statute, or reversal or implied overruling of the decision by a high court, or some such or similar infirmity is manifested in that decision. Now, one more judgment we have in the case of Bombay High Court in the matter of CIT versus Godavari Devi Saraf we spoke about, and one differing judgment we have in the case of Thane Electricity, where the Bombay High Court later on in somewhere 1994 held that the decision of one high court is neither binding precedent for another high court nor the courts or tribunal outside its own territorial jurisdiction. It is well settled that the decision of a high court will have the force of binding precedent only in the state of the territory on which the court has jurisdiction. In other state or states, the territorial jurisdiction of the high court, it may at the best have only persuasive effect. Now this leads towards the next issue that we spoke about, that the high court permutation combinations we have dealt with. Now that comes to a next issue. What would happen if there is a special bench judgment? Number A, what would happen if we have a high court decision, non-jurisdictional high court decision, as well as we have a special bench judgment? The Ahmedabad ITAT was faced with a similar situation in the case of Canal Oil. What has happened in that particular case is the judicial member and accountant member had taken a different view. It was a matter somewhere on some interest, 234 AB interest with respect to some MAT related issue. The Bombay High Court has taken a view in favor of assessee. Special bench was against assessee. Now the issue before the issue before the third member was whether to follow non-jurisdictional high court or to follow the third member. In that particular case, the judicial member held that, the third member held that the decision of the non-jurisdictional high court, if this is the only decision, it would be a binding, but it would be a binding, so they didn't follow special bench, they followed non-jurisdictional high court decision. But then they further said that if there are conflicting decisions of the two high courts are available, and if there is a special bench is there, in that case the special bench decision would prevail, then the tribunal cannot go beyond special bench. Another issue that now we come across is, let's say there are various decisions of various tribunals. So number one, we have only one tribunal, we cannot say that there are various tribunals. Number two, we can have a jurisdictional high court, we cannot have a jurisdictional tribunal, because there is only one tribunal, that is income tax appellate tribunal, and they functions, they have got for administrative conveniences, they have got benches at Ahmedabad, Baroda, Surat, Lucknow, Mumbai, Delhi, etc. But then there is only one income tax appellate tribunal. Of course, if a tribunal falls in a jurisdiction, if the tribunal, let's say, falls in jurisdiction of, let's say, Gujarat, then the tribunal is bound to follow the decision of the Gujarat High Court. If a tribunal functions in a state of Maharashtra, it is bound to follow the decisions of the Bombay High Court. Now that comes a question that, let's say, there is no High Court decision available, we argue a matter and we quote that the decision of the coordinate bench, would that decision be binding? Assuming that a Kolkata ITAT's decision, would that be binding to the Ahmedabad ITAT? The answer is yes. The Kolkata ITAT decision would be equally binding to the Ahmedabad ITAT. May that be reported or unreported judgment will really make no difference. The only thing that needs to be considered is that if Kolkata ITAT has decided a matter in line with the jurisdictional high court, the High Court of Calcutta, and if the contrary judgment has been given by the Gujarat High Court, then Ahmedabad ITAT has to follow the Gujarat High Court. Otherwise, Calcutta ITAT would certainly be a binding decision to Ahmedabad ITAT. Certainly, as we can say that the special bench judgment would prevail over the division bench judgment, and division bench judgment would prevail over a single bench judgment. Sometimes it may so happen that we have two judgments of a same High Court. Now, what is to be done in that particular situation? Let's say we have two judgments of the same High Court. Now, A, what a tribunal should do, which is subordinate to that particular High Court, in that eventuality, first thing that needs to be seen that whether the judgment, the later judgment and the former judgment both have identical facts or not. If they both have identical facts, then obviously the later judgment would prevail. If the facts are different, then the ITAT has to ensure that the facts are matching with which judgment, and that particular judgment would prevail. Now, let's say it may so happen that the facts are matching, identical, but the first judgment was a larger bench judgment, second judgment was a smaller bench. Obviously, in that particular case, larger bench judgment would prevail. The only exception where a tribunal can say that I will not follow the High Court is the case where it is a per incurium or a sub silentio. In that scenario, it can be said that it is that the tribunal is not supposed to, or a tribunal may not follow that particular judgment. The next issue which comes up for a discussion here is whether the decision of ITAT are binding to AO or not. We have Supreme Court judgment in the case of the Kamlakshi Finance, where they have stated that even the decisions of the tribunal are binding to AO. Number of times we face a situation that we go for a CIT appeal, we forward a judgment of the ITAT, and they say that we are not going to accept this particular judgment because this has been argued other way around, this has been argued in a different way, had this been argued things could have been different. Then in that particular eventuality they deny, but then it is certainly a case of judicial indiscipline. We have one judgment in the case of Nestle. It was decided by some advance ruling was taken in that particular case. AO denied to follow that. Against that matter went to straightway High Court. A writ petition was filed in the High Court. High Court came down very heavily on the AO, stating that if it has been decided by the tribunal, one has to follow that. One cannot go beyond that. So this is all about, we can say all about the judicial discipline, which I was supposed to talk about. So the summary is that the court, having a lower court of a lower court, must yield to the wisdom of the higher court. AO is bound to follow ITAT, ITAT is bound to follow, AO is bound to follow, CIT appeal is bound to follow, ITAT is bound to follow, High Court is bound to follow the Supreme Court. Unless there is a judicial discipline, there is going to be a chaos. So this is all from my side. If you have any queries, we can discuss that.
Thank you all for joining us today, making this session a grand success. Heartfelt thank you to today's faculty, Mr. Jignesh Parikh sir, for his insightful talk on the judicial discipline and propriety under Income Tax Act. Sir, genuinely speaking, your expertise is truly added a value to our knowledge today. Thank you very much for all, and special thanks to Ahmedabad branch for the plan such national tax convention. Thank you all. Thank you.